Had the plaintiff got the cause of action is the suit is maintainable. The are the sale deed bearing number so and so executed by Khedan Saw is the defendant number 1 and 2. Khedan Saw and Sona Mato in favor of Chaman Mato and others nullified and not binding on the plaintiff is the suit had.
Chaman Mato is who?
The Chaman Mato is defendant number 4 to 9 lordship. The respondent number defendant number 1
4
and
to 9.
Lordship.
Defendant number 1 and 2. Who is defendant number 3?
Defendant number 3 lordship. The defendant number 1 is a Khedan Saw and defendant number 2 is a Sona Mato lordship. And defendant number 4 to 9 is the Chaman Mato, Reso Mato,
So this Kheda Mehto and Sona Mehto.
lordship.
They are defendant number 2 and 3.
Lordship.
2 and 3. And who is defendant number 1?
Defendant number 1 is Khedan Saw. 1 and 2 is the Khedan Saw and so defendant number 1
1 and 2 कैसे खेदन सा हो जाएगा? एक ही हुआ ना?
हम बोले हैं कि defendant the Sanichia Devi sold the land to defendant number 1 and 2 lordship.
Defendant number 1 was Sanichiriya Devi.
Defendant number Sanichia Devi is not a defendant.
Who is defendant number 1?
Khedan Mato lordship according to
Khedan Mehto is defendant number 1.
lordship.
Sona Mehto,
Defendant number 2.
this is defendant number 2.
The
Who is
San-
defendant number 3?
Defendant is Nathu Mato lordship.
Nathu Mehto.
The defendant number 1 and 2 lordship sold the land to the defendant number 4 to 9 lordship.
Why is this Nathu Mehto coming in picture? Who is he?
The Nathu Mato is a son of Khedan Mato lordship.
The son of
Lordship. Lordship, may kindly see issue framed by the learned trial court.
Yes, I am there.
Now the para 6 lordship, the learned trial court judgment lordship. Para 6. May I read lordship?
Para 6 is issue number
Issue number
4 and
5
5 is formal.
formal and 1
1,
2
2 are the main.
lordship. May I read lordship? Issue number so and so as formal, the issue number 1, 2, 3 are main and material issue. These issues are correlated. These issues are taken together for analysis first. It is admitted case of the parties that the command in Chester, Roop Dev Mahato, living sons Puran, Ugar, Jaipal, separated image in properties and status prior to survey hence the lands of Puran were recorded in possession of the Dukhan, the father of the plaintiff, and his nephew Budhan, who is the father-in-law of Sanicheri and father of her late husband Bikhan. The lands of Ugar were recorded in possession of Chitu, the father of the defendant number 1 and 2 and grandfather of the defendant number 2. And lands of Jaipal were recorded in his name. Puran had 4 sons, out of him Raman and Uttam died issueless, and recorded tenants Dukhan's sons are Nero and Nithu. The recorded in Budhan's sons was Bikhan, who died leaving behind his widow Sanicheria, recorded tenant. The Chitu's sons are the Khedan sons and defendant number 1. Admittedly, the plaintiff Mithu Mato has filed a partition suit number so and so in the court of sub-judge Hazaribagh for partition of the land of Khata number 7 and 10 of the village Dikho belonging to his family members. Admittedly, the basis of the partition suit of the plaintiff is that during the
Admittedly, there was no such issue in that partition suit as
Yes.
to whether the sale deed executed by Mausamat Sanicheria was fuzzy or not.
The basis of the partition suit of the plaintiff is that during the pendency of the aforesaid partition suit number so and so transpired that defendant number 1 to managed to obtain a deed of sale from the Mausamat Sanicheria in the year 1962, who had no saleable interest in the property. The matter was placed before the learned court on on consideration of facts and circumstances of case, the additional subject held that the sale deed executed by Mosma Sanicharia in favor of Khedan South Farji and collusive document, and, and, and decreed the suit. The defendant number 1 and 2 managed to file title suit number itna for setting aside the judgment and decree passed in partition suit number so and so by his son, the defendant number 3, but same was dismissed up to honorable courts. Appeal preferred by defendant number 1 and 2 against the judgment passed in partition suit number so and so was also dismissed, and finding given the learned subject became final, and the sale deed said to have been executed by Sanicharia was given befitting coffin. Thereafter, D2 jealously, the defendant number 1 and 2 could not manage to bring into the existence two sale deed number so and so dated in the year 1988 in favor of the defendant number 7 to 9 again, and again on 11 to 11 1988 in favor of the defendant number 4 to 6.
Who are defendant number 1 and 2? They are the sons of Muhammad Sanicharia.
No.
Then who are?
Defendant number 1 and 2 is the son of Chito Mahato.
Chito's son are Kheda and Sona.
The Khedan Mahato is son of Chito Mahato.
Then how this the sale deed which is involved in this case is related to the earlier title suit?
Lordship, they are same plot of land. Lordship. The previous sale deed was filed in the year 1961, which is the subject matter of the sale deed, Lordship.
Of that particular
suit, Lordship. Therefore, the learned trial court held that it is a Farji and collusive suit, Lordship.
So that particular which sale deed was held to be Farji and collusive? Sale deed number?
During the pendency of the
sale
suit.
Deed number.
Sale deed number.
ये जरा देख लो उठा कर।
The sale deed number is 66. It has been stated in para 9 of the.
That was exhibit B.
Lordship. Para 9 of the plaint, Lordship. That all the aforesaid sale deed are based upon the sale deed to have been executed by Sanicharia number at 6602/1966, which has been declared as a Farji and collusive by the competent court. And exhibit 1 is the Lordship, that judgment and decree passed by the learned trial court, Lordship, in the suit of in the year 1961.
She transferred 4 annas share through the sale deed dated 25/1961 for the consideration of 8,800 rupees.
Ji. But that sale deed also has been declared Farji and collusive, Lordship.
Yes, sale deed by Sanicharia
To the defendant number 1 and 2, Lordship.
that sale deed was to defendant number 1 and 2.
Yes.
Defendant number 1 and 2. चार आना से declared collusive in earlier suit and was also set aside.
नहीं, that judgment of decree passed in the year 1961 Lordship has not been satisfied by the learned appellate court Lordship, affirming the judgment passed by the learned trial court Lordship.
Just a minute. In that case, the sale deed was executed by defendant number 2 and 3.
Like 1 and 2 Lordship. The Sanichia sold the land to defendant number 1 and 2 Lordship.
That's right. So therefore, back-to-back sale deed by defendant number 1 and 2 in anybody's favor would also be null and void.
Null and void. But both the court Lordship that dismiss only on the ground that the sale deed was not exhibited before the learned trial court Lordship. So my submission is that a void document is not required to be challenged before any court Lordship, and therefore Lordship that document has not been exhibited. Although Lordship, I do not need to challenge because the learned trial court has already held that the sale deed executed by Sanichia in favor of the defendant number 1 is furgy and collusive Lordship. And thereafter Lordship, the defendant number 1 and 2 Lordship sold the land to the defendant number 4 to 9
Sale
Lordship.
deed number भी तो नहीं लिखा है ना?
सेल डीड लिखे हुए हैं
नहीं, उस जजमेंट में सेल डीड नंबर भी तो नहीं लिखा हुआ है ना?
नहीं लिखा हुआ। पैरा 9 में देखा जाए टाइटल सूट प्लेट में हम लिखे हैं।
नहीं, प्लेट में लिखे हैं।
हाँ।
Is it an admitted fact?
एडमिटेड फैक्ट Lordship।
Written statement में क्या है?
नहीं, रिटन स्टेटमेंट में नहीं लिखा।
तो ये जो आपका जो प्रीवियस जो आपका सूट डिसाइड हुआ था
जी
सनिचरिया देवी का, जिसमें सेल डीड को बोला गया था कि इट इज कल्यूसिव, उसमें भी तो सेल डीड नंबर नहीं लिखा
सेल डीड नंबर नहीं।
तो कैसे पता चलेगा वो कौन सा प्रॉपर्टी बेची? कैसे पता चलेगा?
लॉर्ड से एग्जिबिट 1 में काइंडली सी लॉर्ड से
एग्जिबिट 1 में ही है,
पेज 23 लॉर्ड
उसी में है हम, और ठीक वही पेज खोल के बैठे हैं जो आप बोल रहे हैं।
जी
हाँ।
एग्जिबिट बी लॉर्ड से
एग्जिबिट बी है, लेकिन उसमें कौन सा एग्जिबिट बी है, उसका सेल डीड नंबर क्या है, कैसे पता चलेगा?
सेल डीड नंबर नहीं है।
तो फिर जब सेल डीड नंबर नहीं है तो कैसे पता चलेगा?
but both the court lords is relying that the sale deed executed by the Sanichia Devi is null and void lords. It's admitted by the both the learned trial court as well as appellate court.
प्रॉपर्टी का सेल डीड को एग्जीक्यूट
वो तो नहीं लिखा हुआ।
तो फिर
वो तो नहीं लिखा हुआ, जो चीज डॉक्यूमेंट में नहीं है उसको गलत नहीं।
तो हम लोग इसको कहाँ से लेके आएंगे बताइए?
but both the courts lords is admitted that
कोर्ट थोड़ी एडमिट करता है, लिटिगेंट एडमिट करता है।
नहीं, फाइंडिंग्स आया दोनों कोर्ट का।
आपने जो आपका स्टेटमेंट प्लेंट में कहाँ था बताइए?
प्लेंट में है जो 9 में,
और उसका रिटन स्टेटमेंट में कौन सा स्टेटमेंट है?
देख लेते 9 पे एक बार देख लीजिए
इसका प्लेंट रिटन स्टेटमेंट। प्लेंट में आपने पैरा 9 बोला
जी। पैरा 24 में भी आया है इनका रिटन स्टेटमेंट में। पैरा 9 पहले पढ़ लेते हैं। That all the aforesaid sale deeds are based upon the sale deed said to have been executed by Musmat Sanichia number as 6602 of 1962, which has been declared as a furgy and collusive by the competent court.
और 1962 तो है ही नहीं, 1961 का सेल डीड है जो पुलिस को दिया हुआ है।
9 हमारे यहाँ लिखा हुआ 1962 लिखा हुआ।
तो हम क्या करें उसका?
बट पैरा 24 लॉट से मेकानिक से रिटन स्टेटमेंट
है। आप जो चीज डॉक्यूमेंट नहीं प्रोड्यूस किए तो ये जो है ये आपका 1962 का डीड है 6602, और ये जो जजमेंट है उसमें 1961 का डीड है, एग्जिबिट बी है था उसमें
61 का।
यस,
मे बी टाइपोग्राफिकल एरर।
अच्छा यहाँ पे अब हम टाइपोग्राफिकल एरर आपका निकालेंगे। इसका जवाब कहाँ है बताइए?
पैरा 24 एक बार देखा जाए तो।
पैरा 9 की रिप्लाई है, पैरा 31 ऑफ
पैरा 30 पढ़िए जरा, क्या है? फॉल्स, डिनाइड है।
पैरा 24 लॉट से निकाल लीजिए। पैरा 24 लॉट से।
ऑफ द रिटन स्टेटमेंट
यस माय लॉर्ड।
24
Yes. That Mosma Sanicharia sold the land of her share, including the lands in suit, to the defendant number 1 and 2 in the year in 1962 ही बोल रहे हैं.
हाँ हाँ
By virtue of registered sale deed of sale, since then the
भाई
defendant
उसमें तो 1961 का सेल डीड है,
one का है.
तो जजमेंट में टाइपोग्राफिकल एरर है,
तो उसमें तो हम कुछ नहीं बोल
तो
पाएंगे. उसमें तो हम नहीं
कुछ नहीं बोल पाइएगा ना, इसीलिए तो आपका ये ऐसा स्थिति हो गया है। अब कहाँ एरर है? और आपने वो सेल डीड नहीं प्रोड्यूस किया। अच्छा एक बात बताइए, जो सेल डीड अंडर चैलेंज था कौन कौन सा एग्जिबिट था?
नहीं, तो उसको तो एग्जिबिट ही नहीं बनाया.
जो अंडर चैलेंज था उसको भी नहीं बनाया
नहीं,
है?
एग्जिबिट ही नहीं बनाया.
कोई भी सेल डीड एग्जिबिट नहीं किए हैं। तो कैसे?
Not required to be exhibited.
अरे भाई दो तरह है ना, एक तो जो आप चैलेंज किए थे सूट में उसको भी नहीं एग्जिबिट किए
नहीं,
हैं,
एग्जिबिट नहीं हुआ. जिसको चैलेंज दिए सूट
उसको भी नहीं एग्जिबिट
नहीं,
किए हैं,
एग्जिबिट नहीं हुआ.
जिसके बेसिस पे चैलेंज किया उसको भी नहीं एग्जिबिट किए हैं।
एग्जिबिट नहीं हुआ.
तो इसका मतलब सनचिरिया देवी जो अपना डीड बनाई उसको नहीं एग्जिबिट किए, उसके बेसिस पे तो 4 डीड आप चैलेंज किए उसको भी नहीं एग्जिबिट किए।
नहीं, उसको एग्जिबिट नहीं हुआ.
आने जमाने में ऐसे ही होता था लगता है।
जो रिकॉर्ड्स
हो गया ना, तो फिर अननेसेसरी देखिए, आपको सुनने में कोई कमी है क्या?
नहीं, हम
तो
कभी
बस
नहीं बोले लॉर्ड से. हम तो कभी नहीं
जो
बोले.
ये जो फालतू केस सब रहता है ना, उसको आराम से कंसीड करना चाहिए। कंसीड तो नहीं बोलेंगे, नहीं कर पाइएगा, लेकिन दिखाई जरा इसका कंस्ट्रक्शन एपेलेट कोर्ट एंड उसमें कहाँ है?
अपीलेट कोर्ट.
ट्रायल कोर्ट में पहले दिखाइए क्या फाइंडिंग। आपके सबमिशन को हम बहुत ट्रस्ट करते हैं, ठीक है ना, इसलिए इस ट्रस्ट को बरकरार
नहीं,
रखें।
हम तो कभी मिसलीड कभी हुजूर नहीं करना. भविष्य में करेंगे हम. एक
कभी
केस
आप
के लिए
ये
अपना
नहीं-
एक केस के लिए अपना इंप्रेशन नहीं खराब करेंगे. कभी नहीं
एक
करेंगे.
केस के लिए 10 केस नहीं खराब करेंगे।
हाँ, 10 केस नहीं, 10 या 100 केस आएगा हुजूर का आशीर्वाद.
अगर आप लोग को केस नहीं मिल रहा है सिविल लिटिगेंट को,
बहुत आप
अभी तो चांदी काट रहे होंगे आप लोग।
चांदी नहीं, प्रेशर बहुत बढ़ गया.
प्रेशर, वकील तो प्रेशर में ही रहना
बहुत
ठीक
ज्यादा.
लगता है।
अब तो थोड़ा सा प्रेशर कम हो गया. एक कोर्ट हो गया हुजूर को, पहले 3 कोर्ट था, तो आप ज्यादा नहीं बोलेंगे, बहुत दिक्कत हो जाती है.
देखिए ये सब करिएगा तो फीस मिलेगा, आप लोग फलिएगा फूलिएगा, हम लोग खुश होंगे, हम लोग को ज्यादा पार्टी दीजिएगा, यही ना है?
जी.
चलिए पुराना केसेस में देखिए लिटिगेंट आके फीस दे के जाता है, जो मेरा एक्सपीरियंस है।
फीस दे के गया, ये बैठा हुआ भी है मेरे चेंबर में.
अच्छा,
हम तो केस पढ़ लिए थे, इसलिए उनको लाए नहीं थे.
ठीक है, चलिए बताइए कहाँ है लिखा हुआ, फाइंडिंग दिखाइए।
जी. भारत से
ये वाला दिखाइए, पैरा 8 पढ़िए।
पर किसी को पढ़ना है. The plaintiffs have supported their case in their chief, excepting both the plaintiffs. None has been examined as a plaintiff's other independent witnesses. Neither any document has been filed in respect of suit land described at the foot of the plaint, nor any reason has been shown by that. The plaintiffs have challenged the validity of 3 sale deeds in respect of the suit land number as so and so dated 11/10/98, but these sale deeds have not been brought on the record or exhibited on behalf of the plaintiff in the suit. The plaintiff has pleaded that in the basis of those 3 sale deeds in the sale deeds executed by the Musmat Sanicharia in favor of the defendant number 1 and 2, number as so and so, यहाँ भी 62 लिखा हुआ, which has been declared as a फर्जी and collusive. हमको लगता है टाइपोग्राफिकल एरर है, इसमें 1961 है, सब जगह 62 आ रहा है. Farji and collusive, but the sale deed executed by Musmat Sanichariya has also not been brought on record or executed on behalf of the plaintiff in this suit. At the foot of the plaint, schedule of the Kewala land has been shown and given. Accordingly, the suit land khata number 10 and khata number 4, Khesra number so and so respectively. I also perused the entire judgment passed in partition suit number so and judgment passed in appeal number itna. In para 24 of the judgment, partition suit number so and so, it has been observed that exhibit B sale deed executed by Sanichariya in favor of the Kedan, which is proved to be farji and collusive document. Sale deed executed by Musmat Sanichariya was thus exhibit B. In that case, has not been exhibited in this case on behalf of the plaintiff. Moreover, para 5 of the exhibit 1 show that Musmat Sanichariya has executed the sale deed in favor of the Kedan on 25/1961. In the present suit, the plaintiff has given and challenged the sale deed number so and so executed by the Sanichariya in the year 1962. It is apparent that the partition suit number Sanichariya has executed the sale deed in favor of the Kedan.
That's it, got it. Appellate court's judgment.
Appellate court judgment. The points has been formulated para 6 first.
Para 6.
G. Page 9 notes. Internal page 9. Para 6. Point for determination of the appeal is that whether the findings of the learned subject Hadaribagh in partition suit number 1161 with respect to the question of fact the sale deed executed by Musmat Sanichariya Devi in favor of Kedan Mato as farji and collusive document and confirmation of finding by the learned first additional district judge Hadaribagh entitled suit number so and so operate res judicata against the defendant respondent. Whether the judgment and decree of the learned court is fit to be set aside or confirmed. The point number 1. It is admitted case of the party that common interest of the plaintiff and defendant number 1, 2, 3. It is further admitted of both the parties that plaintiff appellant filed partition suit in the court of Sir Judge Hadaribagh for partition of land of khata number 7 and 10 of the village Bekhu, and a corporate suit was decreed in favor of the plaintiff with respect to 800 share of the plaintiff. It is also admitted case that the appeal was filed by the defendant respondents and the same was allowed in part and decree of the learned additional district judge Hajari was modified to the extent of 1/6 share in the suit. The lawyer for the appellant tried to impress upon me that the aforesaid partition suit number so and so Sanichariya Devi was defendant number 8 and learned additional subject Hajari while deciding the suit pleased to hold that the exhibit B the sale deed executed by Sanichariya Devi in favor of the defendant number Kedan Mato and defendant number 2 Sona Mato dated 25/1961 is a farji and collusive and defendant when could not succeed managed to execute the 3 sale deeds in favor of the defendant number 4 Since the aforesaid sale deed executed by defendant number 1 to 3 in favor of the defendant 4 based upon the sale deed executed by Musmat Sanichariya Devi bearing sale deed number so and so which was declared as a farji and collusive document. Thus, the finding of the learned additional subject Hadaribagh in confirmation by the learned first additional district Hadaribagh operates as a res judicata against the defendant who claims to the Sanichariya Devi. Learned lower court has answered the point raised by the learned court for the plaintiff in para 8 of his judgment has held against the plaintiff. I find the plaintiff appellant has examined 2 witnesses in which witnesses PW1 so and so exhibit 1 in so and so order of the Honorable High Court in second appeal number so and so. On the other hand, the defendants respondents have examined 5 witnesses proved the certain documents which is marked as under so and so. In order to appreciate the judgment of the appellate court, it necessary to decide whether the sale deed executed by Sanichariya Devi bearing sale deed number so and so is same as that of the sale deed referred by the appellant in this suit. I have gone through the judgment of partition suit number and title suit number and came to following the conclusion that the learned additional subject though did not frame the specific issue related to sale deed dated 25 and executed by the Sanichariya Devi but pleased to hold the same as a farji.
आपको क्या बोलना है respondent?
Yes. He challenged the 1988 sale deeds said to be executed by the defendant number 1, 2 in favor of the other defendants. Now the basis of the 88 sale deed was according to them also 1962 cell date, which we also have heard in our written statement 1962 cell date. This 1962 cell date has never been declared to be furgy or illegal in the previous suit, and their whole pleadings and case is based on the fact that the link deed, the mother deed, has been declared furgy, and so these subsequent cell deeds on strength of those cell deeds should be declared null and void.
And neither the sale deed under challenge nor the
Those-
mother deed,
has been exhibited.
none of them
Yes,
have been
yes,
exhibited.
and therefore
I just repeat, the sale deeds which were under challenge and also the mother deed which was declared collusive, none of them have been exhibited.
yes, nothing is exhibited. And
तो
the
हमें
court-
ऐसा
and
केस
the
तो
courts
देखते ही
below
नहीं
has
आज
courts below has appreciated in
There is
detail
no documentary evidence on record. Exhibit 1 is the only thing.
yes, that previous judgment, previous partition judgment.
1961.
बिना impugned sale deed के कैसे declare हो जाएगा sale deed? Null and void.
Information is in-
And moreover, in the previous suits, the khata number was different, 10 and 7. In this
We
10
will
and
not
7.
bother about it. In the previous one, khata number was also
Yes,
different.
one of the khata number was different. And further, they
From
admitted
where do we get this?
that is there in the findings itself. It has been reported. And their plaint will also show khata 10 and
For
7.
khata number 4. Yes, it is a detailed order. Rather, the appellate court's judgment has also been considered.
Yes, yes.
Chal.
And moreover, they have admitted in their evidence that they have sold their entire share of
ये
land.
2004 से केस ऐसे पेंडिंग रहना चाहिए. हाँ? Essay number 189 of 2004. Heard the learned counsels appearing on behalf of the parties. This appeal has been filed against the judgment dated 16/2/2004 within bracket decree signed on 5/3/2004 bracket close passed by learned 4th additional district judge DDD, dismissing the title appeal number 6 of 1992
लोग इसमें दो जजमेंट हम थे दूसरा का परमिशन
मतलब क्या ही जजमेंट आप देना चाहते हैं? जो सेल डीड आप एग्जिबिट नहीं किए उसको आप उसको
which is not required to be exhibited because the learned trial court has already held that it is the same in collusive lawsuit. Therefore, it is not required to be exhibited.
लाइव जजमेंट
वैसा एग्जैक्ट नहीं है मगर झूठा झूठा
कुछ तो होना चाहिए. पैरा नंबर बताइए.
पैरा नंबर 6 पैरा 6 पढ़ लेना है नोट्स. Para 9. Now I shall refer the question whether the suit bar will limit is contested whether learned counsel for the respondent appellant has prayed for declaration as to his legal status in view of the exhibit 1-7 and a further declaration that she is entitled to success to a state of the so and so. Then the question we raise as to what is the legal effect of document which is ab initio void. A void document is annexed in the eye of law, which is illegal document is something which involves a contravention of prejudice to express or implied provision of law, rule or bylaw. I found a rightly held by the learned municip that exhibit 1/7 is a void, has no legal effect and is annexed in the eye of law. In this case, Lord, the learned trial court has already held that it is the same and further. Therefore, this document is not
Meeting.
one Supreme Court judgment also. Lord.
जबरदस्ती.
एक दो ठोकली दे देते हैं. उनको
आप
लगे
बताइए बिना सेल डीड को एग्जिबिट किए कौन सा सेल डीड आप सेटिसाइड करा दीजिएगा? इट इज समथिंग लाइक रीट पिटीशन में बिना इम्प्यूग्ड ऑर्डर के रीट पिटीशन में भी अलाउड
कभी नहीं
हो सकता है.
कभी नहीं.
फिर अब रीट से समझ में आता है आपको सेकंड अपील भी. तो कुछ
Those are based on admitted facts. Here the facts are not admitted. What
नहीं हम नहीं देंगे कुछ नहीं.
अगला फाइल पढ़ना शुरू करिए.
अगला फाइल तैयार है सेकंड
तैयार है?
हाँ तैयार.
Dismissing title appeal number 6 of 1992/116 of 02 and confirming the judgment dated 10/10/1991 within bracket decree signed on 25/2/1992 passed by Learned First Edition Munsif GDD in title suit number 14 of 1989. The Learned Trial Court had dismissed the suit. This appeal was admitted for final hearing by its order dated 18/2/2009 on the following substantial question of law. The Learned Counsel for the appellant who is a plaintiff, representing the plaintiff लिखिएगा, plaintiff तो मर गए होंगे. Plaintiff has placed the exhibit 1, which was the judgment passed in partition suit number 11 of 11/2 of 1961-62, dated 11 July 1963, and has referred to the paragraph 5 of the judgment to submit that Sanicheria Devi, who had executed the sale deed dated 20/5/1961 in favor of the defendant number 2 and 3 of the same case, paragraph 5 में इसका लिखिएगा paragraph paragraph 24. It has been held that the exhibit B, sale deed executed by Mausamat Sanicheria in favor of Khedan, K-H-E-D-A-N, was proved to be fuzzy and collusive document. The Learned Counsel has further submitted that once the sale deed, which was exhibit B in the aforesaid partition suit of the year 1961-62, was held to be fuzzy and collusive document, all subsequent sale deeds based on the same automatically are automatically to be set aside. The Learned Counsel submits that the judgment dated 11th July 1963, within bracket, exhibit 1, has not been properly considered by the learned courts, and they were wrongly swayed away by the fact that neither the sale deed executed by Mausamat Sanichari was exhibited, nor the sale deeds which were challenged in the suit were exhibited. The Learned Counsel has submitted that the sale deed executed by Mausamat Sanichari, having been declared as null and void, having been declared as fuzzy and collusive document, was null and void for all purpose, and the same was not required to be exhibited. And only the legal effect of such declaration was required to be seen. For this, he has relied upon the judgment passed by Honorable Kerala High Court, reported in 2009, Volume 4, KLT 840. Equivalent citation is 2009 Supreme within bracket KER bracket close 791, paragraph 6. He submits that in view of the aforesaid facts and circumstances, the Exhibit 1 was not properly appreciated by both the courts, and therefore the substantial question of law is fit to be answered in favor of the appellants and against the respondents. The deed executed by Sanachariya Devi having been declared collusive, all the subsequent deeds has no sanctity in the eyes of law. The learned counsel for the respondents, while opposing the prayer, has referred to paragraph 5 of Exhibit 1 and submits that the sale deed executed by Sanachariya Devi was relating to Khata number 10.
Yes.
Was relating to Khata number 10 and was dated 25/1961. He has submitted that the learned courts have taken into consideration the Exhibit 1 and found that it was not matching with the case of the plaintiff,
Yes.
as the sale deed executed by Sanachariya Devi in the plaint was of the year 1962.
62, which has never been declared valid.
And he submits that the sale deed which has been mentioned in the plaint was never declared as null and void, and the statement made in the plaint was also denied in the written statement. The learned counsel has also submitted that it is a peculiar case where neither the sale deed executed by Sanachariya Devi was executed, nor any of the sale deeds under challenge were exhibited. The learned counsel has submitted that the learned courts have taken into consideration all the materials on record, including the appellate judgment arising out of Exhibit 1, and also Khata number 7 and 10, while holding that the plaintiff has failed to prove his case. The learned counsel has submitted that the sale deed executed by Sanachariya Devi and also the subsequent sale deeds were required to be exhibited before the court for comparison and for recording a finding, and therefore the learned court have not committed any error in appreciating Exhibit 1. The substantial question of law is fit to be answered in favor of the respondents, and this appeal is fit to be dismissed. After hearing the learned counsel for the parties, this court finds that title suit number 14 of 1989 was filed seeking a declaration that sale deed executed by defendant number 1 and 2 jointly and severally in favor of defendant number 4 to 9, being sale deed number 10865 and 10866 dated 28/1988, and also registered sale deed number 5745 dated 11/10/1988 be declared null and void and not binding on the plaintiffs. The specific case of the plaintiff was कौन सा पैरा पढ़े थे प्लेंट का?
Para 9.
In paragraph 9 of the plaint was that all the aforesaid sale deeds were based upon the sale deed said to have been executed by Mausamad Sanichari, numbered as 6602 of 1962, which has been declared as fursy and collusive by the competent courts. And in previous paragraph of the plaint, reference was made to the judgment and decree passed in partition suit number 11/2 of 1961-62. The said judgment passed in the partition suit was exhibited as Exhibit 1 before the court. The fact also reveals that the sale deed executed by Sanichariya Devi, which was declared to be collusive in the aforesaid partition suit of 1961-62, was never exhibited before the court. And also the fact that the sale deeds which were under challenge in the present suit were also not exhibited. Upon perusal of Exhibit 1, which is the judgment passed in the aforesaid partition suit number 1961-62, this court finds that in paragraph 5 of the judgment, it has been clearly mentioned that Sanichariya Devi had executed sale deed dated 25/1961 in favor of defendant number 2 and 3 in connection with, in the context of Khata number 10. The finding of the learned court with regard to the sale deed executed by Sanichariya Devi has been given in paragraph 24 of Exhibit 1. Wherein it has been observed that Exhibit B, sale deed executed by Mausamad Sanichariya in favor of Khedan, was proved to be fursy and collusive document in view of the discussions made in the judgment. This court finds that as per the plaint, the sale deed which was declared to be collusive in the aforesaid title suit, in the aforesaid partition suit, was numbered as 6602 dated of the year 1962. However, the Exhibit 1 finds no reference to sale deed number 6602 of 1962 in the entire body of the judgment. The learned counsel for the appellant has also not been able to point out any reference to sale deed number 6602 of 1962 in Exhibit 1. This court further finds that the statement made in paragraph 9 of the plaint was denied by the defendants in the written statement. And therefore, in order to find out as to which sale deed and relating to which property was declared to be furzi in the earlier partition suit of the year 1962-63, 1961-62 was required to be exhibited. The learned trial court has discussed the implication of not exhibiting the aforesaid sale deed which was declared to be collusive in the partition suit of 1961-62 in paragraph 8. Paragraph number what's it?
8B. Right.
In paragraph 8 of the judgment which is quoted as under. The learned first appellate court has also considered the Exhibit 1 in paragraph number 11, यहाँ पर page number 12 का, yeah, I also peruse the entire judgment, ठीक है? I'm just marking it here. Paragraph 12 से ले लेंगे. And recorded the finding as under. Paragraph 10 इसका पूरा अंत तक ले लेंगे, last तक, ठीक है? This court finds that the discussions made by the learned courts with regard to Exhibit 1 is in accordance with law, and there is no perversity or illegality in the matter of such discussion as recorded above. In view of the aforesaid findings, this court is of the considered view that the learned courts have not misconstrued or misinterpreted the judgment passed in partition suit number 11 of 2011 11/02, अपन ये नंबर सही नहीं है, of 61-62 within bracket Exhibit 1. Accordingly, the substantial question of law as framed by this court is decided in favor of the appellant and against the respondents. Consequently, the second appeal is hereby dismissed.
Against the in favor of the respondent.
हाँ
Appellant
हम क्या लिखा दें?
in favor of the appellant side.
नहीं against the appellant and in
अच्छा,
favor
against
of the
the-
respondents.
अच्छा, I am sorry. I am sorry.
पूरा ही गड़बड़ हो जाएगा. चलिए अगला केस वैसे ये जजमेंट का ना एक पैराग्राफ पुट कर दीजिएगा. हम इसको इस पे एक लाइन लिख देंगे. अब आप साइट किए हैं तो क्या ही करें.
Under heading for orders with effect, item 3, first appeal FF 44 of 25.
Yes. What is it?
Worship, there are 4 defects that have been pointed out. Out of which, Worship, the defect number 25, the party name has already been corrected. And same goes of defect number 48, Your Worship. It may be.
जिन्होंने ये नोटिंग बनाया है ना, उनको बुलाइए, उनके साथ बैठ जाइए. अभी बुलाते हैं. We are not able to understand उनका क्या डिफेक्ट है. Remaining. We are just calling him. Just wait for some time.
From the daily list, targeted case under heading for orders, item 1. Second appeal 58 of 1991 along with item 2.
This case I have put for orders. Regard to order dated 7/2/2020. By this case, the substitution was allowed, but the office says that notice was not served. No errors having appeared, but it appears from office note dated 13/6/2022 that errors of substituted errors have appeared through a column.
From where do I get it? Order dated?
Office note.
Office note dated 13/6/2022.
3620.
Office note appear कर गया.
थर्टी 3622 तो कोई ऑर्डर ही नहीं है.
Office note.
Office note.
Office note.
उनका कहना है कि
एक सेकेंड. सारे अपियर हो चुके हैं. Respond number 1A. देखिए 1A, 1B, 1C, 1E to 1J. किस रेस्पोंडेंट की बात कर रहे थे ये लोग? 1 के कितने लीगल ईयर्स थे? आइए नंबर कौन सा था 1 का सब्स्टिट्यूशन?
10655.
10655 दीजिए. इनका वकालतनामा कहाँ है? इसका वकालतनामा होना चाहिए रिकॉर्ड. सबका तो नहीं है, इतने सारे हैं. 1 2 3 4 5 6 7 8. There are 8 legal heirs and successors. बताइए. हाँ, सारे लोग अपीयर हो गए हैं.
रिस्पोंडेंट तो ये रिप्रेजेंट करता है.
तो रिकॉर्ड कौन चेक करेगा आपका 91 वाले रिकॉर्ड में? डू यू गेट इट? आपका केस अगर अलाउ हो जाएगा ना तो आधा मिनट भी नहीं लगेगा सुप्रीम कोर्ट को डिसमिस का इसको एसएलपी अलाउ करने में.
नॉन अपीयरिंग पर
तो आप ही बताइए नॉन अपीयरिंग कौन कौन है? 10 साल और जिसको एडजर्न कर देते. बाकी और भी 2-4 लोग हैं वो भी सब खत्म हो जाएंगे, कोई बचेगा नहीं. टाइम वेस्ट करते हैं, रिकॉर्ड नहीं देखते हैं, क्या करते हैं आप?
he is representing the respondents. He has tried
Meaning some of the
one का भी. इसके किसी
अभी रिकॉर्ड देख के बताइए कौन कौन वकालतनामा फाइल किए. 1D 1D रोमन 2 1D. किसका राइटिंग है? इतना गंदा राइटिंग है. हु हैज रिटन दिस? देखिए, as per the office note, respondent number 1 within bracket 1 was substituted by the order dated 7/2/2020. However, notices have not been issued, nor they have appeared by filing wakalatnama. The learned counsel for the appellant is directed to take steps for service of notice upon the legal heirs and successors of respondent number 1 within bracket 1 through ordinary process as well as through speed post. Office within a period of 1 week from today. Office to track speed post delivery and prepare appropriate office note with regard to service of notice. नाम भी देख लीजिए अपने जितना लोग हैं, दिखाइए उनको. और बाकी सब में क्या ऑफिस नोट है? बाकी सब में क्या ऑफिस नोट है? There are 3 cases.
two cases.
दूसरा केस में
एनालोगस है.
Analogous same common judgment के against में फाइल. We can see order number 4 now.
प्रपोज लीगल ईयर इसमें कोई आईए पेंडिंग है?
इसमें तो कोई आई पेंडिंग नहीं है. यूआई से डिस्पोज हो
ये
गया.
अभी एडमिट नहीं हुआ?
एडमिट हुआ.
नहीं.
4/10/1991
Submitted before the honorable bench for hearing under order 41 Rule 11 CPC.
Lordship, may kindly see order number 4, Lordship, in second appeal number 69 of 1991, Lordship. 4/10/1991 का जो order है. This appeal will be heard along with second appeal number 58 of 1991, Lordship.
Order number 4.
जी.
So what? इसमें कोई substantial question of law तो बना ही नहीं है, तो क्या decide होगा? There is no substantial question of law in this. Yes?
Then Lordship, I will argue, Lordship.
What you will argue? बिना substantial question of law बने हम आपका एक case decide कर.
नहीं, decide तो नहीं, frame करना.
चलिए बहस करिए. क्या substantial question of law है इसमें? इसमें कोई आई है पेंडिंग है? नहीं ना?
The substantial question of law is the one, Lordship, whether the judgment of learned court below allowing the appeal with respect to plot number 144 of khata number so and so and khata number so and so is based on no evidence in purpose.
कौन सा है सब? कहाँ पर?
One, Lordship, page 3 में देखा जाए. My suit was decreed, Lordship, against which they filed, Lordship, appeal.
अब दूसरा केस में कौन सा क्या substantial question of
दूसरा
law?
उसमें है Lordship, may kindly see order number 4, Lordship, 60/1991.
इसमें से कुछ भी मैचिंग नहीं है.
Matching में
हाँ तो आप हमको दिखाइए परवेश.
para 15, Lordship, may kindly judgment passed by the 11th first appellate court, Lordship.
Para 15.
In view of the discussion made above, I find and hold that Musmat Janakpur was in khas possession of land of plot number 210 of khata number 88, plot number 667, 601, 254 of khata number 89. However, I find that Musmat Janakpur was not in possession of plot number 144 of khata number 116, plot number 151, of khata number 120, plot number 623 and 749 of khata number 121 and plot number 251 of khata number 122 at the time of vesting with an intermediary interest in the estate. This issue is inserted against which, Lordship, the second appeal number 69 of 1991 has been filed because the court did not hold.
How do you say it is based on no evidence?
Yes, Lordship, may kindly see the findings of the learned
You
trial.
see, who was supposed to prove that you were in possession?
The
You were supposed to prove.
defendant himself admitted DW3 that the Janak Kumar has possession of the land, and admission before the court is a best evidence, Lordship.
State is also a party.
State is a not party, Lordship.
Then
Lordship, let me complete. Let me बोलिए. Lordship, issue framed by the learned trial court may kindly see, Lordship. Para 8, Lordship. Internal page 5, Lordship. The learned trial court, Lordship. The issue framed by. You, Lordship, got it?
yes, yes, sir.
If the suit land, Raiti land of the plaintiff, has the defendant perfected their title, interest and possession of the suit land, and what relief any to. Now, Lordship, making para 9, Lordship, the findings of the learned trial court, Lordship, which is based on the evidence, Lordship. Para 9, Lordship. May I read, Lordship?
Of the trial court.
Yes. Page 5, Lordship, of the learned trial court, Lordship. the defendant number 3 himself admitted in cross-examination that Janak Kuwar is possession lordship. I am coming lordship. Issue number 4 and 5, these are the most important issue for determination in the suit. Hence, I first take up them for the discussion in support of the claim. Both the parties have adduced number of the oral and documentary evidence. Let us see how far they are acceptable before discussing the other aspects of the case. Following facts are admitted by the party. It is admitted fact that Musmat Janak Kuwar was the owner and in possession of the suit 1930. It is also admitted that the partition suit number so and so was decided in respect of the property of the families of the defendants and performer defendant number 4, in which Musmat Janak Rajkumar was a party. It is also admitted fact that this suit land along with were allotted in Takta of the performer respondent number 4, Musmat Janak Kuwar in that partition suit. Now, was admittedly defendant number 4, who is the vendor of the plaintiff, had his title and possession over the suit land in 1930. The onus is on the defendant to establish his title and possession over the suit land. The defendant number 13 has already admitted in para 3 of the cross examination that land in suit is in their ancestral property and they have acquired it from Musmat Janak Kuwar by oral gift. He further said that this is the basis of the title by DW 15 para 3.
देखिए ये फर्स्ट अपील नंबर सेकेंड अपील नंबर 69
जी 1991.
The learned counsel for the appellant has submitted that this appeal has been admitted has been directed to be heard with second appeal number 58 of 1991 within bracket R, but no substantial question of law has been framed. By referring to the substantial question of law framed in second appeal number 58 of 1991, the learned counsel has submitted that the substantial question of law in that case is relating to plot number 210 of khata number 88 and plot number 601, 667 and 254 of khata number 89. And the present appeal is primarily relating to plot number 144 of khata number 116, plot number 151 of khata number 120, plot number 623 and 749 of khata number 121 and plot number 251 of khata number 122. The learned counsel has submitted that the learned trial court has recorded a clear finding that Musmat Janak Rajkumari Kaur had title and possession over the suit property, but the learned first appellate court in paragraph 15 has recorded that she was not in possession with respect to the aforesaid plot number 144 वाला जो दिया ना, at the time of vesting of intermediary interest in the state of Bihar. The learned counsel has submitted that in view of the
Page
in
9
view of the aforesaid facts, this appeal be admitted for final hearing on the second substantial question of law, the first substantial question of law proposed in the memo of appeal. पूरा ही कवर्ड है ना, कुछ
पूरा
छूटा तो नहीं.
कवर्ड है. DW लॉट ने एडमिट किए हैं.
Considering the आपका कोई अभी रोल नहीं है. Considering the aforesaid submission, this appeal will be heard on the aforesaid substantial question of law.
One thing has been left to be state law by my
इसमें हम notice करें.
The judgment of lower appellate court, I think passed after remand judgment of this honorable court. There are earlier second appeal.
We'll see that. अभी तो आपका तो एक part of property पर आपका बना है, दूसरे part of property पे इनका बन गया. ठीक है? इसमें notice करना पड़ेगा. नहीं
तो appear कर
आप appear कर रहे हैं ना सबकी तरफ से.
appear कर no notice.
The counsel for the respondents, Mr. T.N. Jha, submits that he is already appearing on behalf of the respondents. In view of the aforesaid submission, no notice need be issued in second appeal number 69 of 1991. और इसका आप नोटिस कर दीजिए.
इसका फर्स्ट केस में जो है 158 बना हुआ है.
हाँ?
Representing all the respondents.
No, I am not representing all
He
the
is not
respondents.
representing all the respondents. आप नोटिस कर दीजिए. ऑर्डिनरी प्रोसेस एंड स्पीड पोस्ट दोनों से नोटिस कर दीजिए.
Use का दे दीजिए. Preemptive time use का दीजिए.
क्या चीज?
1 लिख दिया है ना, use का दीजिए.
क्यों 2 वीक्स की प्रेम्प्टिव नहीं किया. हम 91 का अपील में प्रेम्प्टिव ऑर्डर नहीं करते हैं. क्या करेंगे इसको डीएफडी करके? We are not interested in dismissing the case for default. That is not my thought process. 91 का केस में डीएफडी करते हैं, उसके बाद और 30 साल बाद केस को डिसाइड करें.
ठीक है.
नहीं करना. 1 हफ्ता का टाइम दिया, आप ऑर्डर कंप्लाई करें. प्रीएम्प्टिव ऑर्डर ये सिविल प्रोसीडिंग्स में नहीं करने का.
कवर करना पड़ेगा.
हाँ, जो एडमिट नहीं हुआ है उसमें हम प्रीएम्प्टिव ऑर्डर कर देते हैं. हाँ, डेट देते हैं. 22 सितंबर.
Item 3, second appeal 484 of 1991.
Yes, appellant.
I guess file for deletion of the claim number 1.
Any objection? IA number 9453 of 2025 in essay number 484 of 1991 within bracket P. This petition has been filed for deletion of appellant number 1 within bracket A, who is said to have died during the pendency of this case. It has been submitted by the learned counsel for the appellant that the legal years and successors are already on record now. Counsel for the respondents has no objection to the prayer. Accordingly, IA number 9453 of 2005 is allowed. The appellant is directed to delete the name of appellant number 1 within bracket A in cause title during the course of the day. आगे बताइए. Next, what is the substantial question of law?
इसमें हमको टाइम दिया जाएगा.
टाइम तो आपको दे रहे हैं ना 1991 से.
नहीं दे रहे हैं. इसमें वो 2 हफ्ता का टाइम दे जाए.
नहीं, आपका स्टे भी है इसमें, हम टाइम नहीं देंगे. आप हमको बताइए, कम से कम बताइए क्वेश्चन ऑफ लॉ क्या है. शुरू करेंगे तभी टाइम देंगे, ऐसे नहीं देंगे. बताइए. Where is the substantial question of law? Yes. बताइए भाई, ऑर्डर बताइए.
That the substantial question of law is involved in these cases as following.
कौन सा ऑर्डर डेट बताइए.
Petitions पर है.
और पिटीशन से क्या पढ़िएगा, ये तो फॉर्मुलेट हुआ होगा ना. 91 का अपील है.
Page number my lord. Page number 9 in prior copy. Page number 9.
भाई, सब्सटैंशियल क्वेश्चन ऑफ लॉ सेकेंड अपील में कौन से ऑर्डर से फ्रेम हुआ है बताइए.
DT.13.08.2025.
पढ़ी
The substantial question of law involved in this appeal is whether the marriage can be equated
मैरिज इन
against from can
मैरिज इन के बाद क्या वर्ड है अगुमित व्हाट इज अगुमित
from can be equated from गैर मौजूदा from marriage from among the son.
कैन बी ट्रीटेड एज घर जमाई फॉर्म गैर मजूरा फॉर्म मैरिज नहीं होता है घर जमाई
घर जमाई घर
झारखंड में रहने वाले लोग
गैर
घर जमाई को घर गैर मजूरवा पढ़िएगा तो बहुत मुश्किल
घर जमाया घर
अगुमित कुछ नहीं हम बहस करें
इसमें को टाइम था
टाइम देंगे पहले बहस करें
इसमें रेडी नहीं इसने
कोई बात नहीं हम भी तो रेडी थोड़ी हैं पढ़िए एट्टी वन का सूट है चलिए पढ़िए क्या इशू बना ऑर्डिनरी फॉर्म ऑफ मैरिज ऑर्डिनरी फॉर्म ऑफ मैरिज तो घर जमाई फॉर्म ऑफ मैरिज नहीं होता इशू देखिए ना ट्रायल कोर्ट का इशू क्या है
पैरा 9 ऑफ द ट्रायल कोर्ट जनरल
पैरा 11 में है इशू ऑन रिकास्ट ठीक
पैरा
है
11
चलिए पढ़िए तो कौन सा इशू इससे कनेक्टेड है
whether the plaintiff has brought any
उसको छोड़ दीजिए इशू नंबर 4 में है
whether the
वेदर राम हंसदा
Ram Hansa brought his daughter Sarojini Hansda Surajmani Hansda
plaintiff number 1
plaintiff number 1 and her husband plaintiff number 2 is the Agumit her Jamai in 1357 BS as asserted by the plaintiff of plaintiffs number 1 Surajmani Hansda was married to plaintiff number 2 in
चुमना सागा which was never converted into Agumit Kharjamai.
Kharjamai and alleged by the defendant whether the story of position and disposition as alleged by
इशू नंबर 4 पढ़िए ट्रायल कोर्ट का जाते हैं अकॉर्डिंग टू 12 पैरा नंबर 12 नेक्स्ट
according to the Santhal customary law of inheritance of girl married only in Kharjamai from is entitled to inherit her father's property. And in the case in Santhal girl who is married in human or in ordinary form from is entitled to inherit the property of her father. It is stated in para 16 of the DT. Ram Hansda brought his daughter Surajmani Hansda and her husband Devi Murmu Gharjamai in the year 1357 BS, corresponding to 1951 AD, and executed a Gharjamai paper, Exhibit 1, on 9th Ashad 1357 BS. The learned lawyer appearing on behalf of the plaintiff submitted that Ram Hamda, father of plaintiff number 1, Surajmani, number 1, Surajmani Hasta, was not old at the time of the marriage of her daughter with Devi Murmu, plaintiff number 2, and when the law stalled hopes regarding a male child being born at the old age of age, he executed a Gharjamai paper in favor of his daughter and son-in-law with the condition to nurse him in old age and to look after his property after his death. This argument of the learned lawyer for the plaintiff first posed that there must have been long gap between the marriage of plaintiff number 1 with plaintiff number 2 and the execution of the Gharjamai paper, Exhibit 1. P.W. Lai, plaintiff Surajmani Hasta, she stated in para 16 of her evidence that she was married to Devi Murmu, plaintiff number 2, about 32 years ago. This means that she was married to plaintiff number 2, Devi Murmu, in the year 1950. The Gharjamai paper Exhibit 1 bears the date of execution 9th March 1357 BS, corresponding to 1951 AD. The gap between the marriage of plaintiff number 1 with plaintiff number 8 and the execution of the Gharjamai paper is very small, running about a year only, and the argument of the learned lawyer for the plaintiff holds no ground under circumstances of the case. The specific admission of plaintiff number 1 is trial number 1152 of 1979 in the court of Sri D. Pandey, Judicial Magistrate Dhaka, and she married in Gharjamai from with Devi Murmu. This is evident from Exhibit D, which is certified copy of the deposition plaintiff Surajmani Hasta, as P.W.1 has stated in para 1 of her evidence that she was married to Devi Murmu and her husband brought reside at the Madhur as Gharjamai. She did not state anywhere in the evidence that she was married in Arumit Gharjamai. Her evidence indicates that she was married to Devi Murmu in ordinary from marriage. Plaintiff Surajmani Hasta also admitted her marriage with Devi Murmu, plaintiff number 2 in Gharjamai from in criminal miscellaneous case number such and such in the court of Sub-Division Officer Dhaka. Santal Pranaji certified copy of the application under section 144 CRPC was filed by the plaintiff Surajmani Hasta relating to criminal miscellaneous case number such and such, Exhibit 4, and in the she has admitted in para 7 of the petition that that she was married to Devi Murmu, plaintiff number 2, in Gharjamai form, which is wholly inconsistent with the case of the plaintiff. PW1 in para 15 of the her evidence has admitted that she was firstly married to Sadhu Marandi of village Dukman, Dumdumi, and there was a divorce between them. And she further stated that at the time of her marriage with Sadhu Marandi at Dumi, her father Ram Hasda was alive. If Ram Hasda had any intention that his daughter Surajmani Hasda should inherit his property after his death, he must have got Surajmani Hasda plaintiff number 1 married in Jharkhand at very initial stage. The factum of the marriage of plaintiff Surajmani Hasda with Sadhu Marandi of village Dumdumi has been kept concealed in the plain, and her evidence in chief should come out under the presence of the cross-examination. PW1 admitted in the para 17 of her evidence. The Devi Murmu has paternal lands in village Ago, Jori, situated in para 22 of her evidence that Saripo Kudu was the Gop Maji, and Tati Kudu was the Pramani on the occasion of her marriage with Devi Murmu, and they are alive. They are competent person to speak about the form of marriage of Surajmani Hasda, plaintiff number 1, with Devi Murmu, plaintiff number 2. But these two village officials have not been examined, and the explanation has given for their not examination. PW1 Surajmani Hasda denied in para 23 of her evidence that she was not been married in Gharjawai. From she cited Sadi Murmu of Agajori and Sadi Murmu of Madhvan, who inherited their father's property like her, although they were married in ordinary form. These two ladies have not been examined, nor any explanation has been given for their non-examination. The Jamai paper is Exhibit 1, and the signature of the Ram Hasda is Exhibit 1 by 8. From the perusal of this document, no form of marriage of Surajmani Hasda has been given it. The document appears to be conditional paper, and no independent witness in whose response the document was written has been examined in this case. The document has been formally approved by PW8 Jaidev Tudu. He admitted in para 10 of his evidence that the Gharjamai paper was not written in his presence. PW1 Surajmani Hasda did not stated that Gharjamai paper was in her presence. He stated in para 23 of her evidence that the Gharjamai paper Exhibit 1 was filed in criminal courts in proceeding under section 144 and 145 CRPC between the partition. The Gharjamai paper Exhibit 1 indicates that there is no seal of criminal courts on the Gharjamai paper, and as such, evidence of plaintiff Surajmani Hasda that it was filed in criminal courts in prosecution under section 144, 145 or CRP से appear to be false, the defendants have seriously challenged the genuineness of the remand paper and Exhibit 1, and they have supported that it is a forged and fabricated document. The contention of the defendant that the Jharkhand paper is a forged and fabricated document appears to be correct. DW1 is the Vivisan Hasda, defendant number 1. He stated that Jharkhand paper is a forged and fabricated document. His statement has not had challenged seriously in cross examination. Plaintiff number 1, Suraj Mani Hamza, has suppressed her marriage with Devi Murmu in Saga of from DW1 clearly stated that plaintiff Suraj Mani Hamza was married to Devi Murmu in Saga or Chunna form. DW3 who stated that plaintiff Suraj Mani Hamza was married to Devi Murmu of village, that having her husband in village Madhuban in the house of Ram Hamza, he
चलिए, कौन है आप ही रेस्पोंडेंट ना? पढ़ लिए ना? तब बताइए कब कल कर दो।
इसमें 2 हफ्ता
नहीं इतना लंबा टाइम
नहीं 2 हफ्ते टाइम है, 2 हफ्ते
सुनिए,
बाद
पढ़
कोई डेट फिक्स कर
कोई डेट 2 हफ्ता बाद तो हम ही को नहीं पता कि हम जिएंगे कि मरेंगे। अब ये केस तो जिंदा ही रहेगा। नहीं इतना लंबा टाइम नहीं दे सकते। इम्प्यून ऑर्डर पढ़ लिए, बहुत ही छोटा सा क्वेश्चन है, इट्स अ वेरी स्मॉल क्वेश्चन, ठीक है। अब आप बस तैयार हो जाइए, इसमें इतना टाइम नहीं दे सकते। आपको करना है किसी और को करना है?
इंस्ट्रक्शन ले लेते हैं।
किससे इंस्ट्रक्शन लीजिएगा?
क्लाइंट से।
क्लाइंट से क्या इंस्ट्रक्शन लेना है? रिकॉर्ड यहाँ पर है, बहस करिए, वकालतनामा है ना आपका।
आपको 1 हफ्ता टाइम दिया जाए, नेक्स्ट वीक रख दिया जाए, किसी दिन नेक्स्ट वीक किसी दिन रख दिया जाए। नेक्स्ट वीक
At the request of the learned counsel for the learned counsel for the appellant has referred to the substantial question of law framed by the order dated 28/1992. The hearing of this case has commenced. The learned counsel for the appellant submits that the matter be posted in the next week. Post this case on Monday to be taken up at first case at 2:15. Let this matter be treated as matter. Next one. पास ओवर भी है? हाँ डिफेक्टिव वाला पता चला क्या?
पास ओवर के आइटम 3
पता चला?
जी
ठीक कर लिए?
Defect number 48 has to be over here.
क्या है डिफेक्ट नंबर 48?
It is basically it's a typed copy of the award amount. If the matter is admitted and lower court recalls the fault for the same would be.
नहीं नहीं ऐसा नहीं है, क्या इग्नोर करना है?
You don't have the copy.
क्या है डिफेक्ट नंबर 48?
48.
टाइप करिए ना इसको।
Not
And
very
it should
clear
be
with us
handwritten.
also.
हाँ?
It's not very clear with us also. The lower court records.
तो मेमो ऑफ अपील कैसे बनाए?
The
आपको
amount
पढ़ाई नहीं
is-
दे रहा?
It's somewhat readable, but also not very clear.
पेज नंबर बताइए कौन सा? बताइए पेज नंबर कौन सा है जो आपको नहीं पढ़ा रहा?
So I don't have the file this time. I think the senior has gone and the file.
पेज 14 है इसमें। दिखाइए
It
जरा।
will be given in the.
कौन सा वर्ड है जो आपको नहीं पढ़ा?
Apologies, Your Lordship.
दूसरी बार हो रहा है ऐसा, सेकेंड टाइम। उनको याद रहता है ये सारी चीज़ें हम नहीं भूलते हैं। बिना फाइल देके पढ़ा नहीं रहा है, दिखा नहीं रहा है, क्या मतलब है इसका? यस, आपने पता किया ना, इसी पेज के ऊपर है, इसी से रिलेटेड है।
और इसके अलावा जो डिफेक्ट और
और
That
कौन
would be
से
removed
डिफेक्ट?
on
बाकी डिफेक्ट कौन से?
just the name has to be corrected, Your Lordship. Okay. That would be done during the course of the day. Right now. And the sections are right.
पढ़ा नहीं रहा है तो सर्टिफाइड टू बी ट्रू कैसे कर दिए
Apologies.
बिना पढ़े? और सेकेंड अपील में इलेक्शन देने का क्या काम है? सेकेंड अपील, why do you need to have an first appeal?
फर्स्ट
Why do you need to have an annexure?
Your Lordship, it is only just added so that we can show that the appellant number 3 is also a party to the.
FA number 544 of 2025. Learned Counsel for the appellant submits that the defect number 48 be ignored. And he submits that it is fairly legible. And as and when the records will be called for from the concerned court, the original will be available in the records. Considering the aforesaid submissions, the defect number 48 is hereby ignored for the present. So far, other defects are concerned, 1 week time is granted to the appellant.
Your Lordship, just one more thing. Defect number 184 is already corrected.
आपका वो confirm कर दिए?
Yes, sir. That was confirmed.
ये है, ये इसके अलावा जो
So far as the other surviving defects relating to defect number
Your Lordship, defect number 25 and 54 would be corrected during the course of the day. And 184
25 and 54 is concerned, he undertakes to correct the same during the course of the day,
and 184 has already been corrected.
and he submits that defect number 184 has already been corrected.
No more defect, only these four.
Post this case in the appropriate heading, the counsel for the appellant is permitted to do the needful to correct the aforesaid defects during the course of the day. Post this case on 20th August.
Apologize, Your Lordship. Won't happen.
Please don't.
It won't happen.
याद रहता है हमको.
Yes, ma'am.
From the daily list and heading for orders with defect, item 19, SA 89 of 2017.
Appellant. Where is the substantial question of law? ये orders है?
ये defect है।
हाँ बताइए. ये प्रीएम्प्टिव ऑर्डर होने के बाद ही कैसे दोबारा लिस्ट में आ जाता है?
CMP से उसको
हाँ?
CMP फाइल होता है।
CMP फाइलों को लिस्ट में नहीं, उसके बाद भी तो हम एक ऑर्डर किए हैं 13/2/25 को फिर CMP से रिस्टोर हुआ है. दिखाइए CMP का ऑर्डर. Nobody appears on behalf of the appellant. इसका FA number 89 of 2017. The records reveal that earlier this appeal was dismissed on account of non-removal of defects, and now it has been restored through CAP number 451 of 2025, white order dated 18th of July 2025. The appellant is permitted to remove the surviving defects within a period of 2 weeks from today plenary. Remove the surviving defects or file appropriate interlocutory application in connection with one or the other defects. Post this case on 8th of September. If the defects are removed within time, and if this order is complied, post this case on 8th of September. तो इस बार दोबारा नहीं आना चाहिए.
Item 20, first appeal 1901 of 2017.
डिफेक्टिव है. ये भी रेस्टोरेशन होने के बाद आया है.
जी.
इसमें CMP नंबर है इसका 390 और 15 है ना. और ऑर्डर था 9525 का. सेम ऑर्डर कर दीजिए. अपने अपीयरेंस दे देंगे मैम. अपीलेंट एब्सेंट.
Item 21, second appeal 524 of 2017.
In this case, the defects has already been removed, and one defect has been ignored by your lordship. Thereafter, this has come.
आपने देखा होगा ना ऑफिस में. इसमें तो आपका नोटिस आया हुआ है. आपके लिस्ट में नोटिस है. दिस इज अंडर ऑर्डर 41 रूल 11. नोटिस आपके लिस्ट नहीं पढ़ते आप. लिस्ट स्टडी सर्कल बनाइए. नहीं आप सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं पढ़िए.
Lordship, I am not ready because I have not gone through that की the ये under order में 41 rule 11 में. Next date दे दिया जाए उस दिन हम कर लेंगे. ये रिमांड होगा. The best रिमांड होगा.
ऑर्डर लिखाइए. ऑर्डर लिखाइए.
Order disband.
रिमांड आप एज्यूम मत करिए कि रिमांड कोई जरूरी नहीं
No,
है.
this is my conscience says that.
ठीक है.
Therefore, I submitted. Because the first court has not heard this appellant, and thereafter that order has been upheld by the commissioner court. So, Lordship, that once person should be heard first. इसको next week में रख लीजिए, हम पूरा इसको आगे.
किस प्रोविजन में है
ये इसके लिए हुआ था.
87(2).
87 में तो अपील फाइल.
87(2).
87(2) में तो अपील फाइल की है. नीचे डॉक्यूमेंट वेरिफिकेशन का था. और इसमें दो चीज और है. एक सब्स्टिट्यूशन पिटीशन भी है, एक आई है, और एक लिमिटेशन पिटीशन का भी आई है. दो आई है.
सब्स्टिट्यूशन किसका?
These two appellants, Balpan Mahato and Biren Mahato, both have died.
When?
It is Uppan Mahato died on 8/7/2019, and Viren Mahato died on 20th/12/2020.
अपडेट करके ना
The substitution petition
आइए
application.
नंबर SA number 524 of 2017 with IA number 10286 of 2024 seeking substitution of the appeal number 1 and 2 and IA number 2543 of 2024 which is a petition seeking condonation of delay in filing the substitution petition. No, in filing the appeal.
Appeal made.
In filing the appeal, which is barred by 228 days.
220.
Issue notice to the respondents in the aforesaid two interlocutory application for which requisites under ordinary process and speed post be filed within a week.
Proceed one.
Post this case on 22nd September, awaiting service report. Office to track speed post.
One application more, Lordship. One IA is there on 8/6/2022. Respondent has filed an IA for appearance through counsel. That application has been
At this-
8/6/20. IA number to like an application on behalf of the respondent has been filed. An application on behalf of the respondent to grant leave to appear to their counsel and accept wakalatnama in the present second appeal. That means they have already
And
appeared.
this learned counsel for the अब क्या करें हम इनका तो
नोटिस जाने दीजिए, हम नोटिस
काहे के लिए नोटिस जाएंगे
फिर कर दीजिए, इसी को एक्सेप्ट कर
एक
लें.
सेकंड लिखे हैं ना दोनों आइए क्या चीज के लिए फाइल हुआ है. At this, the learned counsel for the appellant has submitted that IA number 4771 of 22 has been filed. See, on behalf of the respondent seeking to
127.
seeking to grant leave to appear through their counsel. वकालतनामा on behalf of respondent number 1 and 2. OP number 2 सिर्फ क्यों लिखा है?
यहाँ तो 227 है.
There are only two
With
respondents.
affidavit 127.
इसमें तो सिर्फ दो ही respondents हैं ना.
वही
Namely Vijay Mehto and नहीं. Respondent
Yes,
number 1
there are
and
two respondents.
1 and 2 has been placed along with the interlocutory application. Considering the fact that the suit is barred, that the appeal is barred by limitation, and there is also a petition for substitution. IA number 4771 of 2022 is hereby allowed. Office is directed to print the name of Mr. Abhishek Prasad. अभी तो इनका नाम ही appear कर रहा हूँ. कर रहा है? The name of the counsel for the respondent is already appearing in the cause list. Two weeks time is granted to the respondents to file counter affidavit in, if any, to the aforesaid interlocutory applications. Post on 8 September under the heading for office. Respondent absent.
नोटिस काट देंगे.
नहीं नोटिस नहीं जाएगा. They are already appearing.
On reading for orders, item 22, first appeal 152 of 2021.
ID number 10452 has been filed for deletion of appellant number 1A, died during the pendency.
Why do you want his name to be deleted? Why do you want his name to be deleted? His legal years are on
Yes,
record.
already on record.
Legal. IA number 10452. of 2025 has been filed seeking deletion of the name of applicant number 1A. The learned counsel has submitted that his legal years and successors are already on record. As appellant number 1 with bracket A. Considering the aforesaid submissions, the IA number 10452 of 2024 is hereby allowed. The counsel for the appellant is directed to delete the name of the appellant number 1A from the cost item in rating during the course of the day. आगे बताइए.
Lordship, against land acquisition reference case, similar matters have been decided by Your Lordship on 30th September.
इसका पहले भी तो था.
हाँ,
Same
हाँ,
kind.
सुरेश माथुर हो गया.
हाँ, कहाँ है वो? Where is that?
First appeal 35 of 1994 के और लाइट में first appeal 76 was decided.
कौन सा हम डिसाइड किए हैं? First
First
appeal?
appeal 76 of 2022.
76 of 2022. Covered cases, sir. Same impugned order. है?
Yes, yes.
Impugned order भी same.
Same, same.
और same कहानी.
Yes.
सभी तो वही था. इसमें रिलाई किया गया है.
Impugned order दिखाइए.
Page 11 it starts.
नहीं उसमें जजमेंट तो इंग्लिश में था.
No, no, Your Lordship, common judgment.
Common judgment.
Yes, Your Lordship, may see that appellant number 2, Banbihari Mato. That was,
अच्छा उनका केस डिसाइड
हाँ.
किया.
वो भी हिंदी में था.
हिंदी में.
आगे वाला हिंदी.
याद नहीं.
हाँ, लिया वाला नहीं.
ठीक है. The learned counsel has submitted that this appeal is squarely covered by the judgment passed by this court in FA number 76 of 2022, which in turn was covered by the judgment passed in
first appeal 35 and 36 of
first
1994.
appeal 35 and 36 of
1994.
1994.
Decided on 1st November 2012.
Decided on 1/12/2012.
12.
Let this matter be placed on Tuesday to be taken up as first case in the second half. 15.
ऑर्डर नहीं.
नहीं ऑर्डर नहीं आया. अभी नहीं हुआ करेक्शन. हमको याद टाइम लगता है करेक्शन करने में.
Item 23, first appeal 47 of 2015.
This notices we issue to the respondents also. They kindly see office notes also.
इसका ना जो एपी नंबर है 76 इसका जरा जिसका भी ये फाइल इसमें भेज दीजिए. आपका है?
Notices we issue to the respondents also. According to office notes of notice of respondent
अरे
number
उनको
5.
बोलिए वो करेक्शन करने के लिए वो चलेगा बिना करेक्शन डिलीट करना था ना उनको. हाँ हाँ बताइए.
Notice of respondent number 5A, 5B received by uncle also. Respondent number 6A, son, 6B, 6C, 19A, 25E, 25C.
Through their WhatsApp
Through WhatsApp नहीं चलेगा.
नहीं चलेगा.
And it is permitted to take various steps also. Through the
WhatsApp?
concerned police station law.
ये इतने सारे रेस्पोंडेंट्स का आपने फाइल किया है.
जी. नोटिस कर देते हैं फ्रेश नोटिस.
IA नंबर 659 ऑफ 24 में 1A एंड 2A दोनों सेम है.
नहीं सेम नहीं है, रिलेशनशिप आर डिफरेंट. लॉर्डशिप में
अरे बाप का नाम से तो पता चलेगा ना.
नहीं एक ग्रैंडसन है. मैं कैन सी पारा 3 लॉर्डशिप. अब मैं आईए
ठीक
नंबर
है,
लॉर्डशिप.
इसको ऑब्जेक्शन देखिए. FA नंबर 47 of 2015. The office note reveals that respondent number 12A, 12B and 14E have been served through their WhatsApp. Also for the appellant, praise for and is granted 1 week time to take fresh steps for service of notice upon the aforesaid respondents. Under ordinary process and also through speed post. Office to track speed post activity.
Respondent 12 है, 12B and 14 है लॉर्डशिप.
हाँ, उसके बाद हम लोग करेंगे इसको जो करना है. Post this case on 13th of October awaiting service.
Item 24, second appeal 82 of 2016.
Sorry? IA for? IA number 9930 of 2017. In essay number 82 of 2016, the learned counsel for the appellant submits that she does not want to press the interrogatory application, seeking stay of execution case number 1 of 2016, which is pending in the court of learned senior judge first Rajmahi. Considering the aforesaid submissions, IA number 9930 of 2017 is dismissed as not pressed. आगे. What else? Second appeal है ना? Substantial question of law पे बहस करें. कोई एडमिट हो गया तो कोई इसीलिए ना आया है डिसाइड करने के लिए. बताइए. Who will argue? कौन सा डेट आपको चाहिए बताइए. आपने मनी रिसीट नहीं फाइल किया है 16/12/24 के ऑर्डर के तहत. यस. The office note further reveals that money receipt in terms of order dated 16/12/2024 has not been filed. The time was allowed subject to deposit of rupees 1,000 by the respondents. कहाँ है respondents इसमें? आप हैं? Are you the respondent? With Jalsa. At the request of the counsel for the respondent is absent. At the request of the appellant, let this matter be posted on. August 20th. In the meantime, the respondent shall deposit the cost as indicated.
Item 25, second appeal 84 of 2016.
Yes, please. क्या है ये?
With respect to earlier the notices were issued, last order was passed on 25/8/2022. In which the 5, 6, 7, 13, 31, 71, 21, 26, 2 and 30, 31, 30 were there. Then as per the
Respondent number 8, 10 and 18 have been reported dead.
Substitution.
Respondent number 22 within bracket 1 and 26 within bracket 1 could not be placed. Learned counsel for the appellant seeks adjournment to take appropriate steps in connection with respondent number 8, 10 and 18 and to take fresh steps for service of notice on respondent number 2 within bracket, respondent number 22 within bracket 1 and 26 within bracket 1 at their present and correct address or to file appropriate petitions in substituted service of notice as per law. Post on 13th October.
I have a letter for some respondents.
पैकेट
I
का है?
to have only also, but I have no copy in the list.
वकालतनामा मिल गया, फाइल करिए, उसके बाद कॉपी ले लीजिए।
No, कारण दो लोग ने फाइल किए हैं। लेकिन हमारा
आप दे दीजिए भाई।
नहीं, वो तो बोले पहले कि
हाँ,
आप
पहले बोले।
आज बहुत ये हो गया।
हाँ।
Respondent number, counsel for respondent number?
वो भी पता नहीं है।
फाइल करते थे कॉपी लिख रहा था।
बहुत अच्छी बात है। चलिए, कॉल करिए।
सेकंड सब उत्तर लगा रहा हूँ।
Item 26, second appeal 155 of 2016.
क्या है? What is this?
Order.
IS filed for the limitation in the previous day, notice has been issued your worship, the limitation. But this problem number 1 and 2 has not been issued.
As per office note, respondent number 2 lives in Bukunda and therefore the notice has been returned unserved. And the addressee has left without instruction. The counsel for the appellant prays for 2 weeks' time to take fresh steps upon service of notice upon respondent number 2 under ordinary process as well as pre-post, for which requisites we filed within a period of कितना आपको टाइम दिया 2 weeks
3 weeks.
3 साल क्यों नहीं दिया आपको
3 weeks.
3 साल थे 3 years वन वीक कर दीजिए ठीक है पोस्ट ऑन 13th October awaiting service report office to track speed testing
Item 27, second April 237 of 2016.
Yes, sir. There are 5 IS substitution.
5 अलग अलग हैं सब विद इन टाइम है
हाँ, ये उसमें
रेस्पोंडेंट कौन है रेस्पोंडेंट कौन है इसमें बताइए कल करते हैं इसको कल करते हैं SA 237 of 2016 close this case
इससे भी आज बात हो गया
sorry
रिस्पोंडेंट नहीं है मतलब
अभी एडमिट नहीं हुआ
नहीं
सब्स्टिट्यूशन पे नोटिस जाएगा ना भाई ऐसे कैसे चलेगा नोटिस गया है पहले कभी नोटिस गया है क्या पूछ रहे हैं कुछ नहीं पता छोड़ दीजिए इसमें बेकार कल हम लोग का ऑर्डर 41 रूल 11 वाले सारे मैटर्स जो आज लिस्ट में हैं कल सप्लीमेंट्री लिस्ट में रहेंगे एंड वी विल टेक अप दोज मैटर्स कुछ मेरे ख्याल से 15-20 हैं तो अननेसेसरी पेंडिंग है ठीक है इट विल बी लिस्टेड इन द सप्लीमेंट्री